and then I'm going to turn it over to our judges.
Welcome to the students. Congratulations on your success of making it to the national finals. As a credit to you, to your hard work, and to the efforts of your teacher. I applaud you for that. I see you're all standing, and I'm going to go ahead and read your question, but at some point in time, I hope you will be seated. As you know, the question today is question 1, and I will read it to you. A result of the decision in Wisconsin v. Yoder is that any parent or guardian can refuse to let their child go to school beyond the 8th grade or learn about a subject by saying it's against their religious beliefs. Do you agree or disagree with this result of the decision? Why or why not? What words, if any, are found in the U.S. Constitution or in state constitutions that protect the right to an education? How have courts balanced religious beliefs with other rights? You may begin.
In the unanimous decision of Wisconsin versus Yoder, the court held that an individual's interest in the free exercise of religion under the First Amendment outweighs states' interest in completing school attendance beyond the 8th grade. We agree with this decision. Compelling Amish children to enroll in public or private schools past the 8th grade would force them to abandon belief and be assimilated into society at large. The Pierce versus Society of Sisters case affirms this opinion. The court ruled that the Compulsory Education Act, which required all school-aged children to attend a public school, was unconstitutional. The government or any general state power should be prohibited from standardizing a group of children.
If an Amish student weren't to leave school after the 8th grade, it is likely that they would eventually drop out. These extra years of high school education would not necessarily advance the student. Amish youth begin apprenticeships and learn a trade that they will use throughout their life. The absence of 1 or 2 additional years of education would neither make the children a burden on society nor impair their health or safety.
The Free Exercise Clause observes the right of American citizens to hold many religious beliefs and engage in religious rituals. It protects not only religious beliefs, but many of the actions made on behalf of those beliefs. This would include the Amish decision to discontinue schooling at the end of the 8th grade. Ideas taught in high school may conflict with the beliefs of Christianity, such as learning about evolution in a science class. This reason contributes to others, but most importantly, it gives leverage to the proposition of leaving school because of religious reasons. The Amish prefer an educational foundation based on agriculture, craftsmanship, and manual trades, hands-on skills that can be advanced without a public high school education.
Consensus on the opinion of any topic can't be forced on any group of people. Constitutional protections, such as the freedom of religion, can take precedence over those of the states. In the Minersville School District versus Gobitis case, Justice Harlan Stone's dissenting opinion said, the very essence of liberty is the freedom of the individual from compulsion as to what he shall think and what he shall say. Issues concerning religious freedoms are protected by our First Amendment rights. State constitutional liberties can't overpower any freedoms that are guaranteed by the U.S. Constitution per the incorporation doctrine of the 14th Amendment.
The founders wanted most aspects of life to be managed by those who are closest to them. They saw no role for the federal government involving the deciding matters of education. Per the 10th Amendment, education decisions belong to the states. In the San Antonio versus Rodriguez case, the court determined that the U.S. Constitution as written does not address or imply power over any form of education.
Education may not be a fundamental right under the Constitution as written, but the Equal Protection Clause of the 14th Amendment creates an inference that when a state establishes a public school system, no child may be denied equal access to schooling. All state constitutions mention the right to education in some way. Section 10 of our Montana Constitution states, a system of education which will develop the full educational potential of each person. The quality of educational opportunity is guaranteed to each person of the state.
Government infringement upon religious rights can only be justified by compelling state interest. An example of applied compelling state interest is the case of Smith versus Oregon. This case clarified, using the 2-part test concerning religion, that an already illegal substance is illegal regardless of secularity. Our panel agrees that religious freedom can only be subdued by compelling state interest. On the other hand, our panel also agrees to identify religious freedom as a right is to recognize that it deserves protection, even in the face of strong conflicting values.
This idea relates directly to the Masterpiece Cake Shop case of 2017. Decisions made in private businesses because of religious beliefs should not involve the government. The religious belief of a private business owner should not be subverted by the decision of a couple where there were other options available. After much discussion, our group came to the conclusion that the court should not have any right to balance religious beliefs with other rights. Religious freedom is the very basis upon which our country was founded. As James Madison stated, religion and government will both exist in greater purity, the less they are mixed together. We are now ready for your questions.
Very good. What tests should be applied to a law that impacts religion, as has been announced by the U.S. Supreme Court?
So I believe the two-part test concerning religion should be one that's applied to any law that's going to try to determine whether something is illegal or not for a religion. And the way that that test works is that it goes through the first part of the test, which says that is this law going, or is what the person's doing going to harm themselves or somebody else? And if it is, it goes to the second part of the test, which then says that if this is already illegal, regardless of whether it is secular or non-secular, then it is illegal either way. And then it would be further decided whether or not it could be made legal if it wasn't already illegal.
Yeah, and like we stated in our opening statements, there are multiple cases that have to do with that test. Like we stated, Smith versus Oregon, but there are others as well.
There was a case, I don't know necessarily if it was a case, but involving the Sundance ritual, that test can be applied to that as well.
So how should we consider, if at all, the child's interests in, say, in education or their other rights against a parent's religious beliefs, if those two things don't always square up? And I'm going to give you a hypothetical. Let's say there's a religious sect that compels their minor age girls to marry and bear children. How should the court deal with that, if at all? How would you weigh those two interests?
So we actually talked about this extensively in our preparation for this question, and we ended up coming to the consensus that the government ultimately has no role in deciding which right would be more important, that of the child or that of the parent. And the other thing that we looked into extensively was, say you can even take the example of Amish children. For the most part, they don't know differently. They don't know a different lifestyle. And we learned that the Amish, they do have the opportunity at some point in their life to experience a different lifestyle if that's what they choose. But ultimately our decision is that the courts and the government don't have any say in which right would be more important in that situation.
So it's this panel's position that there's nothing a minor child can't be compelled to do by their parents on the grounds of a religious belief?
You know, that's a difficult question based on their age. You know, if they're older than the age of 16, they probably have a pretty good example or, you know, idea of what they want to do for the rest of their life. Under the age of 16 or maybe even 12, it's a difficult question to answer because, like Paige said, those are, you know, things that they're just growing up around, and they know that to be correct, even if, you know, the rest of society doesn't believe that to be correct for that child.
What if there's a risk to their health?
Yeah, that's a good question as well. We actually did talk about, you know, religious beliefs against, you know, like blood transfusions, and if that child needs a blood transfusion, but the parents are against it. And ultimately, we did decide that the government doesn't have any say in that. And you would just have to trust, you know, like the doctors at the hospital, what they believe is right. But it is a good question, and it's hard to say that the child would have, you know, a stronger belief than their parent if they are, you know, younger than the age of 12 or maybe even 16.
Should public schools students be allowed to participate in religious clubs held on school grounds after school? Why or why not?
Personally, I believe that if a school is going to allow clubs, they should allow clubs of any standpoint. They shouldn't be outlining all religious practices within schools. If you don't want to teach religious class, I completely understand that. That's what religious schools are for. So personally, I believe that if the club would like to practice religious ideas after school, that's perfectly fine.
To add to what my colleague was saying, while we do have the right to a freedom of religion, we also have the right to freedom from religion. So if there's a religious club being offered and you don't feel comfortable with that, you don't have to participate. Because like I said, you can choose to not participate in any religion at all, just the same as you can choose to participate in whatever religion you would like.
Yeah, and as long as the school, you know, didn't discriminate against any religion, and they said that any kid could hold any religious club for, you know, any religion at all, and they weren't outlawing one religion versus another religion, I think it would be okay.
May the government ban any particular procedure allowed by a religion such as polygamy?
Could you repeat that?
Yes. May the government ban practices that are allowed and even recommended by individual religions such as the Mormons? Can they ban polygamy?
So I'm speaking for the panel here. I think we all came to an agreement that government shouldn't be involved in marriage. We tried to figure out if there was any benefit, like tax benefits, being married to more than one person, and we haven't found that out necessarily. So we don't think that the government should be involved in marriage and stuff.
However, to bring up the further question of polygamy, they actually did ban polygamy for the Mormon culture. For Utah to be accepted into the union as a state, Utah, as most of us know, is mostly Mormon. They outlawed polygamy to be accepted in the union. However, most Mormons, not most Mormons, but a fair amount of Mormons will actually still be married into the afterlife, not necessarily here on earth. And I can't think of the actual name for it, but there is a name for that.
So you said a lot of shoulds, but do you know what the government, what the actual position on the books is today with respect to the question that Judge Volpe just asked?
You know, I'm not sure on the exact position today. Yeah, all I would have to say about that is that, you know, our panel did decide that the government should have no role in your marriage or anything as personal as marriage. I mean, there's really nothing that they can do, you know, about it. And like Garrett said, those Mormon people are getting married into the afterlife, as they say, you know, even if it isn't here on earth. So the government's not really
So marriage shouldn't be regulated. Parents' decisions about their children shouldn't be regulated. What should the government, or what can the government regulate over a religious exception?
As we talked about in the first question that we were asked, we believe that the only way that the government can regulate anything involving religion would be through compelling state interest, or if it was deemed illegal or harmful based on our the two-part test that we also mentioned in our prepared remarks.
Do you have any examples of that?
What specifically?
Of something that there would be a compelling state interest to regulate?
So we mentioned the case of Smith versus Oregon in our prepared remarks. And that case deals with peyote, which is a substance that is illegal, whether it is being used for secular use or non-secular use. And in this case, it was decided that since it was already an illegal substance, that it couldn't be used in a religious practice.
We've run out of time. Thank you, students, for your presentation. I enjoyed that very much. And I will tell you that I appreciated hearing what you believe to be an appropriate situation with regard to the wall between church and state, and with regard to the right to an education. You pointed out that by and large, the right to an education is addressed in state constitutions. You cited the Montana Constitution, and I thought that was very, very interesting. You mentioned Minersville versus Scobitis about whether or not those who have a religious objection can be required to salute the flag. It was upheld in Gobitis, but you should know that it was overruled in a subsequent case, West Virginia Board versus Barnett, which said that a student cannot be compelled to salute the flag or pledge allegiance to the flag based upon their religious prohibition against that kind of activity. But the rest of the presentation I thought was very, very interesting. You had some very interesting observations about the compelling state interest as to whether or not the regulation is justified on the part of government. You pointed out Smith versus Employment Division, which said religious beliefs cannot shield you from an otherwise generally applicable law. And that was the use of peyote. There is a subsequent case that overruled the prohibition on peyote. I would love to have the time to discuss that with you, but we're running out of time. And the question that I ask you about polygamy and whether or not it could be prohibited refers back to a Supreme Court decision in the case of Reynolds versus US. And it held that government can ban polygamy simply because it is harmful to the common good and society. And so polygamy is not allowed under current law. But with regard to the remainder of the comments, I'm going to turn it over to my fellow judges.
Sure, I'll jump in here, and Judge Volpe probably doesn't know this, but he skipped all of the intros, and you guys did a great job just rolling with it and sitting down. That's very much like what might happen in, you know, a courtroom or with congressional testimony. You just roll with it, and you showed incredible poise just digging into that, and I was glad to see it. A good reaction from all of you. And I really did enjoy our discussion. You seemed you were very eager to get into the conversation. I would have liked to have seen a little bit more return to you know, the materials. So just like Judge Volpe said, there's a law in the books about polygamy. There are age of consent laws for minor children that would regulate the marriage question that I asked. And there, you know, but it was good to kind of hear your argumentative style, because I think you made a decision as a unit, and so you kind of went into this as we're gonna defend our position, and you were very effective at staying the course. But I think it would have been a little bit more persuasive if you had brought some of the case law to bear and started teasing out the differences between them. But it was a fun presentation to listen to, and thanks for the hard work to get you here.
Thank you.
And Judge Volpe, would it be okay to have the introductions done?
Yes, please.
I'd like to know who
I realized well into my first question that I had forgotten to introduce the students.
I've done that before too. So why don't you introduce yourself, and we'll have the kids.
I'm Paige Maynard.
I'm Garrett Rose.
I'm Keegan Crowley.
I'm Bailey Chapman. We're all seniors at Laurel High School, and our instructor is Mr. Depp.
And your judges were, I'm Edward Volpe, an attorney from Denver, Colorado. And my colleagues are.
I'm Caitlin Johnston. I'm an attorney in New York City.
I'm Ed Murphy. I'm a Superior Court judge in Tacoma, Washington. And I was impressed with the teamwork that you had and everybody sharing the load. And not only just in the initial 4-minute presentation, but in answering the questions that you chimed in and agreed and then added on to what others had said, with some subtle differences in what you had to say. I want to commend you for being engaged in this program and for the things that you're doing as far as learning about the Constitution, not only of the United States, but also, as you've demonstrated, your own state. That puts you far ahead of not only kids in your age group, kids in college, but people in this country, that you know more about the Constitution than most of the people in this country. And that is very commendable. And do not lose that eagerness to learn, to think, and to educate, to talk to others about that and the importance of that. And I appreciate the presentation that you had today. And I would echo much of what my fellow judges have said, but thank you.
Thank you.
Thank you.
Okay, congratulations, students. We're going to offer you a round of applause for a job very well done. I'm going to go ahead and stop the recording now at this time.